The structural points that I wanted to make is that, as John has alluded, there are no kind of accounting provisions in the Emoluments Clause, Article 1, Section 6, Clause 2. It doesn't say that, the emoluments whereof shall have been increased at the end of the term on net when you subtract out, there's none of these kind of accounting terminology and so forth. And indeed, one of the points that then Professor Breyer, now Justice Breyer, at the time of Saxby's appointment made in writing to Robert Bork, one of the points that he made, I'm sorry, I am confusing Breyer with Larry Tribe. Their jurisprudence or their views on the Constitution are similar, and they were colleagues at Harvard at the time. Actually, Breyer made the point. We can take them in any order. Breyer made the point that part of the purpose of the Emoluments Clause wasn't just this anti-corruption provision. He didn't mention the broader anti-growth of federal government argument that John raised, but he said that part of it was that clearly after the particular person for whom the fix was put into place was no longer in that civil office, Congress would raise the salary again, and indeed that has happened with every one of the appointments since the Taft example. So it's really not a deterrent to the increase in salary, and there's something fishy there. What Larry Tribe has said, as recently I think last week or the week before he blogged about this, was unlike the escape hatches in, let's see, Article 1, Section 9, Clause 8, and the third section of the 14th Amendment, there are no escape hatches, no escape clauses to allow fixes here. So here's Article 1, Section 9, Clause 8. It says that, quote, no person holding any office of profit or trust shall, under the United States, shall, without the consent of Congress, except of any present emolument, office, or title of any kind from any king, prince, or foreign state. So you can't take a lordship or a knighthood or one of these things without the consent of Congress. So Congress, if you manage to get that consent, then you can get that. And Section 3 of the 14th Amendment prohibits office holding by anyone who ever, quote, engaged in insurrection or rebellion, quote unquote, against the United States, obviously referring to officers of the Confederacy, or quote who quote gave aid or comfort to the enemies thereof. And this has its own escape clause, quote, but Congress may by a vote of 2/3 of each house remove such disability. So again, there is precedent that other disqualifying clauses of the Constitution have escape hatches. So if Congress, if the Constitutional Convention had wanted to put in provisions sharpening the point that this was purely an anti-self-dealing provision, they could have. They could have said, whose net pay shall not have been increased in the language of the 18th century, or they could have said which increase shall not have been voted on by the particular member, or something to that effect. There could have been an escape hatch. As Madison said, as John quoted, he was very concerned about the creation of offices and the increase in salaries. That was his greatest fear of corruption, not that one particular member of Senate or the House would collude with his colleagues to create an office for him, although that was a worry as well. Okay, now let's move to the bill itself, which might as well be called the Hillary Clinton Relief from the Constitution Act of 2008. The emoluments, the practical effect of this is that the emoluments, and again, emoluments means salary and other certain benefits, generally tied to something financial. I mean, if you give the Supreme Court new comfier chairs to sit on the bench, I don't think that's a type of emolument. There's a question with Hugo Black in the 30s of whether a provision allowing Supreme Court justices to retire at age 70 on full pay was a new emolument. But anyway, it's pretty clear that the increase in salary, if anything, is an emolument. So this bill moves the emoluments of the Secretary of State's office back to what they were on January 1st, 2007, which was 2 days before Senator Clinton assumed the current term that she's serving now. The second provision of the bill, of the joint resolution, provides that for civil actions to challenge any actions by the Secretary of State. So anyone who has had, the precise language is, any person aggrieved by an action of the Secretary of State may bring a civil action. And the U.S. District Court for the District of Columbia has exclusive jurisdiction over that. So I don't think there's any way, either under this bill or in general, that you can manufacture standing or some other way to challenge the appointment before Senator Clinton or Senator Salazar, in this latter case, actually assume the office. Once they do assume the office, however, so who could be aggrieved by an action such that they could challenge it? Well, the simplest thing is probably a denial of a passport, say, one of these functions that the State Department does. Obviously, the Secretary of State herself or himself isn't reviewing each passport application and stamping yes or no, but it's the only reason that particular line officer in the consular office, in the passport office, is doing that is because of delegated power directly from the Secretary of State. So that could be probably the simplest thing. What other types of adverse actions? I don't know, certifications of a particular consul. You could think of different ones. In any event, they could bring this suit. So, Tom, if you're looking for plaintiffs for a possible challenge, I would look for someone who's been denied or not had their passport renewed or something like this. For whatever ground, you can just, as lawyers, we can throw the kitchen sink in whatever claims we make. So even if they were properly denied their passport because, they're not a citizen or something, you could say, also the action was improper because even though under, in a real case, they should still be denied, but, And then just mechanically, it would be a 3-judge district court of the District Court of District of Columbia with provision for a direct appeal to the Supreme Court. And interestingly, and I didn't go back to look at the Lloyd Benson relief from the Constitution Act of 1993 or any others, but interestingly, this says that the Supreme Court shall accept jurisdiction over the appeal, advance the appeal on the docket, and expedite the appeal. I'm not sure whether this means that they have to actually put it on their oral argument calendar. It might be that they just have to take the appeal and in a per curiam order deny it. It's probably that. But it's interesting that they actually do have to consider the appeal and not just reject it for lack of jurisdiction or something like that. Let's see. I will note that I think the strongest argument against the position that I'm making and that most that have kind of scholars that have studied this, and that her appointment and Senator Salazar's appointment, mutatis mutandis, are unconstitutional, is this one that not only did Hillary Clinton not vote on this particular pay increase, and not only was it a cost of living adjustment rather than some other type of increase, but the Congress that voted on this, I mean, it was in the early 90s. It was so far removed from anything from today. Indeed, nobody had to do anything for the cost of living adjustment to even go into effect. Yes, President Bush signed an executive order in January of this year, kind of certifying or propounding, I guess emphasizing would be the word, that there was to be a COLA. But the words of the actual congressional statute that provided for it in the early 90s was that the only way that the COLA would not go into effect for cabinet offices was if the president certified that it not go into effect for whatever reason. So the president didn't have to do anything. It wasn't even that his executive, it wasn't even that he needed to have signed this executive order during Hillary Clinton's term, and that's what makes that her salary has been increased under the terms of the clause. So that's something that some Congress did 15 years ago, disqualifies someone now from being a civil official of the United States. That seems kind of odd, but again, that's a policy argument, and it's not a textual one.